Mr. Kirkman?
Good morning. May it please the Court, my name is Tom Kirkman and I represent the Commonwealth in this case. This is the Commonwealth's application for further appellate review is granted because the appeals court reversed the defendant's conviction due to what it found to be prosecutorial error in the cross-examination of the defendant at trial as well as in the prosecutor's closing argument. There was no error, but there are two very discrete issues that arise out of this case and the prosecutor's conduct at the trial. The first had to do with the prosecutor's cross-examination of the defendant as it regards his having an opportunity to review police reports prior to the trial, in advance of the trial. The issue initially came up as a Commonwealth versus person error. The appeals court found there was no person error, and indeed there wasn't. And there wasn't for a couple of reasons. One is certainly after the U.S. Supreme Court ruled in the Agard case that there is no Sixth Amendment violation by a prosecutor commenting in her closing that the defendant had an opportunity to tailor his story based on witnesses that he saw. This court in Gaudet, which is cited in my brief, said that the person error arises if the prosecutor's comments are not based in the evidence. And the person error, as it has played out in the cases, arises when the Commonwealth makes a closing argument that the defendant tailored.
Well, I understand about the Agard case, but why should we necessarily follow that? I mean, in other words, it seems to me that at least there's a good argument that, you know, part of what we've been doing with discovery is to give defendants access to discovery in order to give full meaning to a fair trial, why should that be, fertile ground for the Commonwealth to explore?
Well, the reason is having to do with the defendant's rights. The defendant clearly has a fundamental right to discovery, to know what the charges are. The defendant has a clear fundamental right to prepare an adequate defense. What the defendant doesn't have a right to do, though, is take the stand and fabricate a story. And the Commonwealth does have a right to challenge a defendant's credibility when it appears, or it certainly is arguable, that the defendant fabricated their story in the wake of certain information.
It wouldn't be fair. I'm sorry, go ahead.
Mr. Kirkman, can I just read a quote from the trial, and you explain to me how this isn't the prosecution taking advantage of the defendant's silence. Here's the prosecutor. Well, in 2001, you were arrested for rape. True? Defendant, that is true. And these charges have been pending ever since. Exactly. And at no time have you reached out to anyone from the Barnstable Police Department to explain your side of the story, that it's all a big misunderstanding. Well, the defendant doesn't have to reach out to the police to explain their side of their story and say it's a big misunderstanding, do they?
They do not.
Okay, let me continue. So the defendant says, no, I figured I would come to trial and do that. And then in final argument, the prosecutor says, and in 2001, when the defendant was finally charged with this offense, why didn't he go to the Barnstable police and explain his version of the events? That this was an old spurned lover who had filed a report years before, and certainly she wouldn't want to go forward since they now hadn't seen each other in years, and certainly any animosity she may have had for him in 1995 had waned. But yet he didn't. Doesn't that suggest he should have gone to the police and he should have explained his defense to the police?
What you're asking is actually the second problem, which is the so-called Doyle error. And I would answer your question by saying that what the prosecutor was saying there is alluding to is the fact that the defendant has already talked to the police. In 1995, he spoke to the police and was informed that the victim here had claimed that she had been raped and that he understood that he might have been identified by her as the rapist. He acknowledged that in his cross-examination. And so and he also stated that his brothers, I believe he had 6 brothers, he said, all of whom were friendly with the Barnstable police. And he stated that.
He said, why didn't he go to the Barnstable police and explain his version of the events? But yet he didn't.
She did say that. There's no question about that.
That's
Isn't
error.
that bad?
That's error.
Isn't that bad?
Well, it certainly is bad, or I wouldn't be standing here today. And whether it's error or not, though, I don't believe it's error because it's grounded in the evidence. And it's.
No, but
let me.
The evidence can't be asking a constitutionally impermissible question.
That's correct. The evidence cannot be asking a constitutionally impermissible question. The defense here, though, as articulated by the defendant in his direct testimony and then on the cross-examination that is not at issue, was that that the victim here was keeping him silent about an ongoing consensual relationship. This whole case is about his silence. And
But it's really not his silence. I mean, if she had said, you went to the police and you talked to the police and you told the police that you didn't know this woman, correct? That's fine. That's evidence.
That's correct. And she didn't say that. I mean, the record is clear on what she's saying. I would, however, suggest that the implication is that he had talked to the police and the jury had heard that he had these other opportunities to talk to people because it's in the context. And again, the statement, I would ask, be taken in the context of the entire closing plus the instructions that the judge gave at the beginning of the trial, at the end of the trial, and what the prosecutor said in her own closing that, what I say is argument, it's not evidence.
But isn't this going to occur in every case if we permit this? Certainly every rape case or sexual assault case where they claim consent as a defense, you're going to have this kind of, how come you didn't go to the police and say she consented? And then the argument about it, it'll be all over the place.
In your example, Justice Graney, that is absolutely correct, but I'm suggesting that this case is a little bit different because of his police activity and because he kept saying, my defense is that she wouldn't let me talk about it, and I wanted to talk about it. I left my underwear in her bedroom so that her husband would know that I had this relationship.
You're arguing that in the specific facts of this case, that type of a question was proper.
Well, maybe.
Given that was his defense, was that I wanted to speak about it.
That's correct, and I am arguing under the specifics of this case. The prosecutor's statement, there's no question, when the prosecutor's statement is pulled out, taken out of that context, is offensive. There is. But I'm arguing that it's not error in this case. And
but she recast the argument as a Doyle error. Instead of arguing the facts of the case, the prosecutor said he didn't go to the police. I mean, she effectively said why didn't he go to the police? Well, he did go to the police. I mean, they did talk to him. Instead of saying the story that he told you today is not what he told the police, way back 5 years ago, she seemed to be saying that he didn't say anything. She went out of her way to recast her argument in a way that violated the Doyle case.
Well, I don't think it violated Doyle because his right to remain, the Miranda warnings hadn't been given, and his right to remain silent wasn't implicated by that in the same way that it was in Doyle and the Doyle line of cases.
I'm sorry. I was very confused by this argument in your brief. Yeah. He's arrested. I've never seen an arrest in which Miranda warnings were not given.
Perhaps.
And the prosecutor is referring to what he did or didn't do after he was arrested.
That's where I understand the court's confusion because, frankly, I got a little bit confused by this too. But what happened here is there was the charge in 1995, and the case sat. This was a so-called cold case hit because of the DNA.
Right.
In 2001, which is when the DNA was secured from him, he was under arrest. He was arrested for an assault and battery by dangerous weapon, according to the record. And he clearly was Mirandized then. In the suppression hearing,
He was arrested for ABGW in connection with another offense.
Totally unrelated case.
Right,
Totally
okay.
unrelated case. And the detectives who were working on this case learned he was in custody. And that's when they went to the police station and they got the discarded cigarette and did the DNA match. But he was Mirandized then. He wasn't charged with this, apparently under the record, until about a year later, until the DNA results came back and firmed up the case that this individual certainly was present at the scene that his DNA was found. And so the Doyle problem doesn't arise because, at least if I'm looking at the prosecutor's argument, she's talking about in 2001 when he's arrested. He was Mirandized then, there's no question about it, but it was for the assault and battery dangerous weapon.
Well, it says here, and in 2001, when the defendant
When he was arrested.
Well, it says, this is her argument, and
Or
in
charged.
2001, when the defendant was finally charged with this offense, why didn't he go to Barnstable Police and explain his version? So are you suggesting that he was charged with offense, knew about it, but he wasn't arrested?
No, I'm not suggesting that. I'm suggesting that the way I was reading that was that he was charged with another offense. He wasn't charged with this offense till later, because otherwise it wouldn't be correct. He wasn't charged with this offense in 2001.
So why should he have said anything about this in 2001 when he wasn't charged with the offense? No one has an obligation to talk about his romantic life with the police.
That's correct, because my answer to that would simply be that he had already talked to Detective Blanchard before she was interviewing him again in 2001 or meeting with him again in 2001. And what the prosecutor was trying to assert there is you've had this conversation with the police, so why not tell the police in 95, in 2001, when you're talking to the same detective, and given your family relationship with the police about this ongoing consensual relationship.
She's saying he didn't talk, so you shouldn't. He's not trustworthy. You can't believe him.
I'm sorry.
Wasn't she really saying he didn't talk to the police? He didn't go to the police, so you can't believe him, as if he had a duty to do that.
And I agree with the court that he does not have a duty to do that. And I also agree with the court that that is what she's saying, that he's not credible. Because
Mr.
he is
Kirkman,
saying...
If the prosecutor had simply tried to do what we would normally call a sort of classic impeachment with a prior statement, members of the jury, let me tell you what he said when he went to the police. You heard what he said today. Let me tell you what he said to the police. You heard. I mean, there's no problem there. That's what you call, it's in the evidence. I think the problem here, as Justice Fina suggests, is she's taking that argument and essentially, inviting a Doyle error, even if it's technically not a Doyle error.
But if we look at, there's 22 pages of transcript of her argument. If we look at how she builds to that, there is a certain logic to it when she gets to that point, and then she moves on in terms of her attack on the defendant's credibility and marshaling the evidence that supports the prosecution's theory of the case.
This is a strong case against the defendant, it would seem, from the evidence. It was an old case. It was an important case, I would assume, for your office. Why aren't prosecutors informed and you're having a very difficult time justifying what she did. You're doing the best you can. Why aren't prosecutors informed to stay away from this subject? Can't we get that message across, that it's just foolhardy to do something like this?
It's certainly, I understand the court's point. The prosecutor who tried this is a very skilled prosecutor. She's one of the best in the office, if not one of the best trial lawyers. And certainly she understands that. She and I have talked about it. I'm a trial lawyer, and I understand it as well. I don't know if that necessarily saves the day for the Commonwealth on this issue.
Could you address none of this? There was no objection to any of this. Correct?
That's correct.
To any of it.
That's correct.
Not to the questions, not to the closing argument. Could you address the substantial risk of a miscarriage of justice?
And I was going to close with that. I see that I just have a half a minute left as to why there's no substantial risk, even if this court does find error. And the reason really does go to the strength of the Commonwealth's case, the positive evidence supporting the case, the reports from the ex-husband, the police, the hospital worker, the evidence of a prior break, the jailhouse snitch, and he wasn't, he was a friend of the defendant's, who said, the defendant said, I broke in and stole some jewelry and there's an attractive woman in there. And also the lack of credibility, and that really is what was involved in here, and that's why this prosecutor, I would suggest, said what she said, is that the defendant says, I want the world to know about this relationship. And if I'm not allowed to tell, I'm going to leave my underwear there so that everybody will know it's me. And I'm going to call DSS and say I've been dealing drugs out of her basement, with or without her knowledge. It depends on how you read his testimony because he contradicts himself. Well, if that's what he wants to do, then why not attack his credibility? But the point is that that's not a credible defense. And that's why, under the substantial risk standard, there was no substantial risk that the jury decided the wrong way, frankly. And I think when we apply the Acevedo test or Azar or Alphys, whichever case we want to draw from, it comes out the same way. That whatever the prosecutor did not lead to a reversible error and a reversal of this conviction.
Thank you.
Thank you very much.
Mr. Safar?
May it please Your Honors, Aziz Safar on behalf of Melvin Ewing. To the extent the defendant's pre-arrest omissions to Detective Blanchard were allegedly inconsistent, our position is they were perfectly consistent with her questions, which is really an unfair situation for my client. The defendant testified he did finally learn the complainant was alleging rape when Detective Blanchard informed him and when he read about it in the paper. But this reference to the complainant's identity appears to be a statement made in hindsight. For example, we know Section 24C commands, Section 24C of Chapter 265 commands law enforcement to initially shield the identity of such complainants, and nothing in the record flat out states that Detective Blanchard discloses the complainant's identity at that time. And this was the early interview in 1995, a non-custodial interview.
So I take it your point is his defense is this was a consensual relationship that she did not want the world to know, correct? And when he is initially interviewed, he does not know that she has complained of rape?
Correct. And not only that, the record does not spell out that at that time Detective Blanchard actually informed him of who this complainant was. So he was
so he doesn't even know.
So he's somewhat in the dark. Yes, and she asks Detective Blanchard asked the defendant about his whereabouts the night of the incident, which allegedly happened in the day, and the defendant answers accordingly. And he doesn't know that he's being accused, and when asked about a rape, the defendant answers, I'm unaware of any rape. So unlike the situation in Commonwealth versus Sherrick, which is cited in my brother's brief, where that defendant gave a detailed statement to police, an inconsistent detailed statement to police, which ran across the timeline of that incident. This defendant's omission, the fact that this defendant omitted mention of his relationship with the complainant, really is too ambiguous to implicate his right to discovery and a meaningful defense. This case is more akin to Commonwealth versus Jones, which is an appeals case, where in that case the defendant had some pretrial discussion with law enforcement, but omitted a fact that he later testified to at trial. And the appeals court held that the prosecutor's argument that the defendant tailored his testimony via discovery amounted to reversible error.
Mr. Safar, yeah. I know that we didn't get to this until the very end of Mr. Kirkman's case, but let us assume that we agree with the appeals court that there was error in this case. None of this was objected to at trial.
None of it was objected to, and notwithstanding the prosecutor's repeated references and recurring theme relative to the defendant's post-arrest silence, an objection would have not caused any further harm, but still that should have placed Judge Conan on notice to issue curative instructions, which he didn't in this case.
Were they requested?
No.
They were not requested.
So we really are here, on all on all fours with substantial risk of a likelihood of justice.
I understand. And the problem in this case is that the case was a credibility contest. Only the complainant and defendant were eyewitnesses to sexual relations. And the defendant posited that his
But
relationship...
wasn't that business about selling marijuana out of her cellar just ludicrous?
I don't know if it was ludicrous. That's what he testified to. That may be an interpretation of the evidence. He testified that he was keeping marijuana in the back of her house, at the bulkhead of her house. And the reason he testified about that was to show that he was, in a way, threatening her to go public with this relationship. And she did not want to do it. And that was one of the reasons why he left his shorts there so her husband would see, and that he also threatened to call DSS on his children.
But leaving the shorts there, the husband, was he at work? Obviously he was gone because the woman was alone, and she had plenty of time to remove the shorts.
Well, that was a determination for the jury. I mean, I can't get into the jurors' minds as to how they would
But
interpret that piece of evidence.
what I'm saying is that makes the defense very incredible and unlikely.
Well, I'm
she
not
has
so
hours
sure.
to remove the
well,
shorts.
she testified to some bizarre things, too. This was her next-door neighbor. She said she had never seen the man before in her life. But I would continue with this and say that his defense was that it was a consensual relationship, and the prosecutor's argument, improper statements and argument, drove at the heart of that defense. And notwithstanding the prosecutor's repeated references to the defendant's, prosecutors suggested on 3 occasions, twice during cross-examination and then in closing arguments, that the defendant had this obligation to affirmatively go to Barnstable Police and explain his version of events. And this just jumps out right at me. You look at the record and it's there, and I suggest that it was enough to cause the judge to issue curative instructions. But the situation culminated with the jury coming back with a question that was in line with the prosecutor's improper argument, that that if the complainant could have dropped the charges, then the defendant should have gone to police to acquit himself. And then, of course, the defendant was convicted. So I suggest on these facts, the substantial risk test has been more than met.
Can I ask you a question going back
Certainly.
to where you started?
Yes.
I thought his testimony in trial was that in 1995 he had been made aware of who the complainant was and that she had alleged rape. Is that simply is that a fair characterization of his testimony?
I would say not. It's not clear because Detective Blanchard had this interview. It was a non-custodial interview in 1995.
I'm talking about his testimony. I
Well,
know
his testimony, and I'm stating that because of the way it came in, he says that after he spoke with Detective Blanchard, he was made aware that the complainant was alleging rape. But I'm stating that it appears that statement was made in hindsight because he also goes on to say it wasn't until 2001 when he was arrested. It was really 2002 that he was arrested on these charges. Mm-hmm. And it wasn't until 2002 that he finally realized she was describing him as a light-skinned black man, that she was alleging him, and he understood the whole circumstances of the situation. So with that backdrop, it seems to me that when he's saying, I found out the complainant was alleging rape, it seems to be a statement that he's making in hindsight. It doesn't appear, and especially given Detective Blanchard's testimony, she never says that I identified the complainant. And he says he knew nothing about a rape at that time. So the only information he would get about a rape, if we take this testimony to mean what it is, would be what Detective Blanchard told him.
But that doesn't make sense. If a police officer is interviewing someone and asking them about a rape, they just can't say, did you rape anybody? Don't they say, there's a complaint that you raped so-and-so?
Well,
particularly when this is years later.
No, this was not years later.
This was in the first interview.
This was the
right?
first interview, a few days. This was
but-
very preliminary.
But you ask a suspect if they were involved with this person. They don't
I don't
just
think
say,
that's what she was asking him. I think the tenor of that testimony was that did you hear about something happening here? And he says he was out until 2 o'clock in the morning the night before, and he gives her names of friends. So at this point, it's very cursory, and she's just looking to, basically in a general investigation. I don't think he was a suspect at that time.
The complainant had not accused him at that time. The complainant had not identified
correct
your client as
That's correct. If we're taking his testimony,
he was a neighbor.
His testimony is that she never identified him throughout the case as the assailant. But his testimony is that he did not know that he was the suspect to whom, about whom she was speaking until he was taken into arrest. in 2002.
Presumably, the police, if they don't know that he's the suspect, are conducting I don't know who else the police interviewed, but they would certainly have interviewed, people about, did you hear anything, did you see anything, do you know anything? But it's a little unusual. Are you saying that at that time in the 1990s, that in the initial interview, that he didn't know who the victim was, or he did know the victim?
I'm saying a reasonable interpretation of this evidence in the eyes of the jury is that he may not have known whom Detective Blanchard was speaking about when she was asking these general questions about a rape. In 1995, a few days after it happened, this was the alleged incident happened on the 13th, and I think Detective Blanchard interviews him on the 19th. So it's just a few days afterward. In fact, he gives her some names, and she says, I looked up these names, and none of these names match the description. She's looking for people who match the description that the complainant had given her in the initial interview.
But why did Detective Blanchard interview him 6 days later? I know that the sniffing dog led up, went from the victim's house right over to his house. And his mother wouldn't let him in the house, wouldn't let the police in the house.
That's correct.
But what led is there anything in the record that indicates what led the police to interview him 6 days later?
The defendant testifies that he was called in on the 19th, and that's pretty much it. I mean, an inference would be there that one of the reasons is that there was a track leading to the side of his house, and they wanted to question people at that house. And then when he provided them with names of individuals he had been out with, allegedly the night before, she also looked into those individuals to see. So he wasn't the only suspect, if you want to call him a suspect at that point. This was all preliminary. And then the prints are eventually matched in 2001, and then they have this ruse situation that I talk about in my brief, and they obtain his DNA, and then he's arrested a year later on these charges.
Does he get was he cross-examined about why he didn't tell the police he was with her that night in 1995? I know he was trying to protect the secrecy of the relationship, according to his defense. But here she's accused him of she's made an accusation of rape, and he is now facing those charges. Did the prosecutor ask him why he didn't, override this pact of secrecy and explain what had happened, just to get out from underneath the rape?
Do you mean to police or to civilians?
To the police.
Yes, she did. That's the problem.
And what did he say? No, that's not a problem.
Well, she asked him. She said, why didn't you reach out to Barnstable Police in 2001 and tell your version of the facts?
But did anybody ask him why he didn't do it in 1995?
No, not that I'm aware of. There are some general questions where the prosecutor asks him, well, did you tell members of your family? And he says, well, my sister knew. And he says, well, if you wanted to go public with, she was suggesting if you wanted to go public with this, why didn't your family know? And he says, well, I still had a girlfriend. So, I mean, an interpretation there would be, well, he wanted to be accepted by her acquaintances, but he still had a girlfriend. He wasn't prepared to announce her to his.
But did Detective Blanchard tell him what house had been broken into that night in 1995?
That's not clear from the record.
Did the judge inform the jury that what was said in final argument was not evidence?
Yes, I believe that was there, yeah.
Oh, they always
I think
do.
didn't the prosecutor say that? Didn't the prosecutor herself say that?
Yes, there was a, but I mean, this is a lot here, because two occasions she's cross-examining him on this, and she's really pumping this into the jury, and then she comes back in closing argument and says, well, why didn't he go to police in 2001? And it spurs this jury question that the jury really took this to heart. And the question was exactly in line with this improper argument, that if the complainant could not have dropped the charges, then the defendant should have gone to police and acquitted himself. And, of course, he didn't do that. So it shows, I mean, I think in this case there's and it is a credibility contest. My brother mentioned Daniels, but Daniels' testimony was essentially benign. All he testified to was that the defendant told him there was a pretty woman who lived in the house behind his, and that there was some jewelry that came from that house. He doesn't specifically say that the defendant took the jewelry. And given the letter that was the consideration, the letter that Daniels had written to Officer Murphy, the Dennis police officer, the jury could have applied the limited weight to his testimony as well, because he was looking to curry favor with law enforcement to gain a more lenient sentence. So I think Daniels is out of the picture. I think this is a true credibility contest. And what the prosecutor did here was unfairly tip the balance in their favor. And the juror's question really speaks to that.
What was the question again?
The question was, the suggestion of the question, I could quote the question for you. But the suggestion of the question was that if the complainant could have dropped the charges, then why didn't the defendant go to police to acquit himself? But let me see the actual quote here. It's quoted in the appeals court decision.
All right.
Did you want me to read that, or did you?
No, I'll find it.
Okay.
Thank you.
Was there any cross-examination of the defendant as to whether he had gone to the victim and said, if you had this relationship with her, why didn't you go and talk to her about why she?
There was some cross-examination with regard to the break-in, which occurred on January 7th. And the prosecutor asked the defendant, did you talk to her about the break-in? Weren't you concerned? I mean, you were seeing her. And he says, no, we didn't talk about that because she didn't tell me anything about this break-in. And we're talking about the break-in involving the jewelry.
Yeah, well, did he explain how his fingerprints had gotten on the window of the house?
Well, he did testify, as Justice Callan pointed out, that he was keeping drugs at the back of that house. So I guess
But wasn't the dirt found on the daughter's bedroom window? That's how he got into the house.
Well, that's one interpretation of the evidence, but when police initially had gotten there immediately after the scene, she had said, and everybody else had said, the person must have had a key. That's how the person entered. And then
But then his fingerprint was found on the windowsill of the daughter's bedroom. That's why I say the evidence is so strong in this case, and the defense seems so made up out of whole cloth.
I don't know if that makes the evidence.
What is his fingerprints doing on the windowsill of the daughter's bedroom?
Well, if he's keeping drugs at the back of the house
But the back
from
of the house,
summer,
didn't he say in the basement?
the bulkhead, which is
Right, I know bulkhead is the basement.
in that range, and
To do
I
with
know they
basement.
built a shower in that area since then. But if he's all over the back of the house from all the way from summer into the fall, it's a likely interpretation for the jury. It's not unbelievable for them to conclude that his imprints would be all over the back of the house.
But except for the atmospheric conditions on that day, at least according to the testimony, were that the prints could have only been there for 4 hours.
Edward Campbell, the person who lifted the prints, testified that his opinion was not scientific, but he personally believed, given the conditions, that the prints were left within the night. So the jury was entitled to give that testimony its limited weight. He himself stated it wasn't based on any type of scientific fact. And then in addition to that, when the scene was still fresh and police had gotten there, the complainant had said, no, I locked everything. I had been robbed a week prior. There's no way anything was unlocked. The person must have had a key. So the jury could have taken that, and another reasonable interpretation would be that, well, maybe the person entered through the front door with a key. I don't think that's the only interpretation, that he entered through the window, and that's what makes this credibility contest what it is. And I believe I believe the prosecutor's improper statements and arguments improperly swayed it in their favor. If there are no further questions.
Thank you, Mr. Safar.
Thank you, Your Honors.